Hi, this is Hubertus Schacht from Higher Regional Court Munich 1, and you're listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 130 of IP Fridays. Together with my co-host Ken Suzanne, I welcome you to this episode. And as usual, before we jump into the interview with Hubertus Schacht, who's our guest today, and we will talk about the Nagoya Protocol and what implications it has on, especially on litigation and on patent strategy of pharmaceutical companies, and also especially the litigation of pharmaceutical patents from US companies. Before we jump into this interview, I have some news for you. Ford received an injunction in Germany, and they cannot, at least the injunction says that they cannot sell cars anymore in Germany. That was quite an interesting decision. Ford obviously had forgotten or did not take a license of certain mobile phone patents. Most of the car manufacturers have taken a license, and Ford so far had refused to take a license of these patents. And now probably they had to learn the hard way. Let's see how the second instance will come along, and let's see how that case will evolve. The European Patent Office opened voting for the European Inventor Award 2022. So if you want to vote for your favorite inventor, you can do so at popular-prize.epo.org. The link is in the description. The EPO has also informed the public that it will no longer distribute copies and documents attached to parties' submissions, including patent and non-patent literature cited in party submissions, as well as documents containing amendments, such as amended sets of claims. And they will not be automatically forwarded to parties. They can be downloaded in the online file. Now let's jump into the interview with Dr. Hubertus Schacht. Today's guest is Hubertus Schacht. He is a judge at the Higher Regional Court in Munich 1, one of the main patent litigation courts in Germany, and I would say in Europe. And his pet peeve is the Nagoya Protocol. We are discussing whether an inventor is an inventor of the patent or also could be a biopirate. Thank you for being on the show, and maybe you can tell our listeners a little bit more about you.
Thank you, Rolf, for having me here. Thank you for giving me the opportunity to speak to you and, of course, your very distinguished audience. As you already said, I'm a judge at the High Regional Court in Munich doing patent litigation. I wrote my thesis on patent law, and I also worked before in the patent law department of the Federal Ministry of Justice, where one of my dossiers has been the Nagoya Protocol. When I am allowed to make a short disclaimer, I am a judge, that is true, but my opinions shared with you here, they are only my very personal views. Thank you.
Yes, of course. I forgot. We are only discussing on a personal level. We are discussing his personal views. So I'm also mentioning this below in the show notes. But I'm very grateful that you're on the show, and that you, because you have helped drafting this protocol, or you were involved in this protocol. and the becoming of this protocol. Maybe you can tell us a little more about the Nagoya Protocol and what it is for.
I think the Nagoya Protocol is about access and benefit sharing. So we call it shortly ABS provisions. Basically, it's about, as it says, access and benefit sharing of biological or genetic resources and traditional knowledge concerning genetic resources. The Nagoya Protocol is kind of part of the Convention on Biological Diversity. I'm not sure whether many of you have ever known about this convention. It was adopted in the CBD, Convention on Biological Diversity, was adopted in 1992 at the United Nations Conference on Environment and Development in Rio de Janeiro, the so-called Earth Summit. And this convention, the CBD, is the only international instrument comprehensively addressing biological diversity. It has, in fact, 3 objectives, which there are the conservation of biological diversity, the sustainable use of its component, and the fair and equitable sharing of benefits arising from the utilization of genetic resources. And to tackle this third goal, the fair and equitable sharing of benefits arising from the utilization of genetic resources, the Nagoya Protocol was developed. It's called Nagoya Protocol because it was adopted at the summit in Nagoya, Japan. The Nagoya Protocol has as goal to be an international regime within the framework of the CBD to promote and safeguard the fair and equitable sharing of benefits arising from the utilization of genetic resources.
Okay, and my take is that this protocol has been put into law both in the EU and in Germany already. So what other countries have been ratifying the Nagoya Protocol? And yeah, maybe you can share a little bit about the territorial scope, the current scope of the Nagoya Protocol.
I think basically a lot of countries have are already members or signatory states of the CBD as well as the Nagoya Protocol. I think all EU member states are signatory states as well as the EU itself. However, one major player, one major country, of course, the United States of America, they are not a member or signatory state of the Nagoya Protocol. But before now, all your US audience will start making something other and not listen anymore to us because they say, well, we are not interested in because we are not signatory state. I don't think it might be that easy.
Right. So just to give the listeners a little bit background, what this really means, the Nagoya Protocol. My understanding from before the Nagoya Protocol was that corporations or any inventors basically could just find out that a certain compound or a certain substance from, let's say, a rare plant or a rare organism from the deep sea or something had some certain effects, basically, for example, being effective medicament against a certain cancer type or something. And then they could just patent the use of this this substance against this particular disease or so. And this Nagoya Protocol wants to bring some justice, basically, or some wants to introduce some fairness toward for example, indigenous tribes also in this field. So maybe you can explain a little bit what the practical implications of Nagoya Protocol are.
Yes. you've just mentioned it. I think the ABS provisions, they were basically driven by demands from the so-called developing countries, because the idea or the perception is that especially countries in the southern hemisphere, they have a lot of a lot of nature, a lot of genetic resources, and Western countries, Western companies come over there, grab the genetic resources, go back to the laboratories in the West, and develop nice patents, nice blockbusters, and get all the benefits out from that, without giving any pence to the countries where the genetic resources come from. So, and this has been seen as unfair, and so it was, as I said, an idea of the Convention on Biological Diversity, and especially the Nagoya Protocol, to create an instrument which establishes a fair access and benefit sharing of the use of genetic resources, and also the traditional knowledge concerning genetic resources. So it's like if you are interested in genetic resources, you should come at broad daylight to the government of the country where the genetic resource is settled, and say, I've heard that this, I have the impression, I have the idea that you have a special genetic resource, and this might be very interesting to me, because I could make this could be a promising drug candidate. Let's agree on terms how I can access this genetic resources, and how I can give you a fair share of benefits I might get from this final product. So this is the basic idea of the Nagoya Protocol, I think.
Yes, and looking at the Nagoya Protocol, there is not a really clear, obvious, direct link between patent law and the Nagoya Protocol. However, of course, the patent law and the Nagoya Protocol are interlinked. Can you explain how this works? And for example, if Article 53C EPC, just as an example, is relevant here?
You're perfectly right. I think so. A general perception would be, well, Nagoya Protocol is about compliance with access and benefit sharing provisions, and has nothing to do with patent law. I think the patent lawyers all over the world, they think Nagoya Protocol is not their cup of tea. I'm not so sure about that. You just mentioned Article 53 of the European Patent Convention, which basically states in its paragraph A, it says European patents shall not be granted in respect of inventions, the commercial exploitation of which would be contrary to ordre public or morality. So question would be, if a company has grabbed a genetic resource from a country which is part of the Nagoya Protocol, and is now demanding for a patent for this genetic resource, or an application of this genetic resource, and has not complied with any ABS provisions, would this something to be considered as being contrary to ordre public? So the question would be, is the compliance with Nagoya Protocol part of ordre public? Yes or no? That would be the first question. Another question would be, well, Article 53 says patents shall not be granted in respect of inventions. The commercial exploitation is contrary to the ordre public. So another question would be, is the compliance of ABS provisions part of commercial exploitation, or is it something before? From a first view, ABS compliance has nothing to do with commercial exploitation. So it would not be considered as within the scope of Article 53, paragraph A. On the other side, if you say, well, there has been access and benefit sharing according to the Nagoya Protocol, but they are obviously not really fair. They are using the patents, but based on agreed terms, which are absolutely unfair for the access providing country or the access providing tribe. One could say, well, it has something to do with the commercial exploitation, and then you might say, this will not be, this should be, a patent should not be granted in this respect.
So basically, the Nagoya Protocol also has an effect on patentability. Do I understand you correctly?
It could have.
So I'm curious, I have a question regarding the inventorship. If the large corporations are going to, for example, the Amazonas region and discover a tribe that is using a certain compound for treating a certain disease, would then these tribesmen or women be co-inventors of the patent? How is that? How does that work out? Like, is there? Can you explain that?
Thank you very much for this question. So I can only speak, of course, of the German law, but I think from a German point of view, there would be very good chances for this tribe or this group of people to claim co-ownership. As regards the Nagoya Protocol and the implementing EU regulation, it is an obvious goal that traditional knowledge associated with genetic resources is protected by the access and benefit sharing provisions. So yes, they could be regarded as co-owners, which leads, from my point of view, to rather practical problems. Because one question would be, might there be a buyout of this co-ownership? One could say yes, but on the other hand, at the same time, you would have to be in compliance with the access and benefit sharing provisions of the Nagoya Protocol and of the EU regulation. So there you should be very cautious by attempts to buy out the co-ownership. Another very practical problem from my point of view could be when there is a group of people or a tribe as a co-inventor, with whom do I have to negotiate? With the chief, or do they need to build a legal entity? This would be very interesting and is not, from my point of view, tackled by the ABS provisions, and who has to be registered in the patent register as co-owner. Rather practical questions, but there might be some issues to deal with. Yes.
Yes, in an article that you have recently written, I saw that basically a patent can be excluded from, or an invention can be excluded from patentability if you violate the ABS regulations, the provisions. Would that be also? Can that be used in, for example, in litigation, or can you explain?
As for now, since I am a judge who deals only with patent infringement cases and ownership and co-ownership cases, it never happened in our courtroom. But this does not mean that it will not happen in some days. So we have the EU regulation, which implements or aims to implement the Nagoya Protocol. And we have, from my point of view, a very, very interesting provision in this implementing regulation of the European Union. It's Article 4, Paragraph 5 of the regulation, and it says when the information is insufficient or uncertainties about the legality of access and utilization persists, users, I mean the user of the genetic resources, and of course the beneficiaries of the genetic resources, shall obtain an access permit or its equivalent and establish mutually agreed terms. So that means you should stick to the ABS provisions, or discontinue utilization. If you're a company which has a genetic resource as foundation of its patent and you sue another company for patent infringement, the defendant might come to the very nasty idea to claim that you are not entitled to claim an injunction because you have not complied with the ABS provisions. And then the defendant could refer to this cited Article 4, Paragraph 5 of the EU regulation, which basically says if you cannot prove or you have not fully agreed with ABS provisions, you shall discontinue utilization. Another argument could be, it's one of the recitals of the EU regulation, it's recital 30, which says that the member states should ensure that infringements of the rules implementing the Nagoya Protocol, so the ABS provisions, are sanctioned by means of effective, proportionate, and dissuasive penalties. I would say what is more dissuasive than to not allow a patent holder to claim injunction if he has not complied with ABS provisions.
And also, I would say utilization could also encompass patenting. So discontinuing utilization, that could also mean discontinue the protection of the patent.
Definitely, yes. On the other hand, you could say, well, these whole ABS provisions, they are about fair access and benefit sharing. And because of that, they are third parties, like the defendant, they are not entitled to claim provisions which regard ABS, which regard ABS, and therefore the third party, the defendant, will not be allowed to claim, let's say, Article 4, Paragraph 5 of the EU regulation. This would be the argument of the claimant, I think.
Right.
But there has not been any, as far as to my knowledge, no dispute, no infringement case in which this question has already arisen.
Let's see if there's case law building up regarding the Nagoya Protocol. We just talked about litigation of patents that is closely related to licenses, because licenses are usually not taken on, or sometimes not taken voluntarily. So can you explain what this could have, the Nagoya Protocol could have implications on license contracts and licensing?
Well, I think it's also if you have a patent regarding genetic resources, you would have to apply the ABS provisions. And if you do not, your patent might be weak, and of course, then the worth of your licenses are not all too high. So it would be very important as well for the licensor, then for the licensee, to make sure that the ABS provisions are fulfilled, and so they should be taken into account while discussing the terms of a licensing agreement. On the other side, if you are a company and you want to buy a patent or a patent application, let's say from a startup, which has a very promising drug candidate, and you want to have it, but the foundation of this patent application is again a genetic resource, then you would have to make sure that the ABS provisions are met because otherwise it comes back to you, and you might have a lot of problems when you cannot prove that while accessing this genetic resources, you were in compliance with the ABS provisions.
Okay, now that we have discussed licensing, most of the listeners are from the US and IP professionals from the US. You mentioned that the US is not part of the Nagoya Protocol or did not ratify the Nagoya Protocol. Would that have any implications, for example, on litigation if a US corporation is, for example, a plaintiff or a defendant in Germany or in any other EU country that ratified the protocol? Would that have any implications?
Here again, I can say that neither the Nagoya Protocol nor the EU regulation give a direct answer to this. But I think we might have a little hint in the EU regulation. It's Article 2, paragraph 4, which says that the regulation applies to genetic resources and traditional knowledge associated with genetic resources to which access and benefit sharing legislation or regulatory requirements of a party of the Nagoya Protocol are applicable. So from my point of view, that means that it is sufficient that you have one party which is a part or member of the Nagoya Protocol, and then the whole regulation will be applicable, which could mean that if you're a company from the United States applying for a patent in the EU, which is obviously a member of the Nagoya Protocol, the provisions of the regulation are applicable.
Right. So they must follow the rules when they are party to litigation proceedings in the EU or any signatory, basically.
Yeah, this could. I think this would be a sound argument. Yes.
Okay, so that's very interesting because, as we all know, Germany is a playing field for patent litigation, an important playing field also for the US companies. We have talked a long time now about the Nagoya Protocol and the question of Inventor or Biopirate. Thank you so much for your time and for your insight. For the listeners who want to learn more about this topic, you have written really interesting articles, one being in the IP journal GRUR, G-R-U-R. I'm linking to that below in the show notes, and another one in the biotechnology report. I'm also linking to that article as well in the show notes. So if people want to learn more, especially the people from the US might be interested in the biotechnology report article. If they also want to get in touch, if the listeners want to get in touch with Dr. Schacht, you can find his contact details on the website of the Higher Regional Court, and he might be happy to answer your questions or get in touch with you. And I'm very grateful that you have been on the show. Thank you for your time and thank you for your insight.
Thank you for having me here for this nice chat. It was a great pleasure for me.
Thank you so much.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.